All right, everyone. In this video, I'm going to walk you through the most common nightmares that turn partners into enemies and show you exactly how a solid written agreement can save you from a financial and personal ruin. I'm Santiago Cueto, board-certified international business law expert and best-selling author. Now, as a Florida business attorney, I usually get the call when the fire is already raging. Too often, I bought in after the damage is done, when partners are at each other's throats and the business they built together is collapsing. My goal here is simple: to give you the information you need before you get to that point, so your joint venture can be a sole source of success, not a soul-crushing litigation. So let's dive right into it. That handshake deal you just made for your Florida business, it's a ticking time bomb and it could cost you absolutely everything. I've seen partnerships with incredible promise end in a full-blown disaster, with one partner losing their home, their savings, and their reputation, all because they sealed the deal with just a handshake. So what makes a simple handshake so dangerous here in Florida? Well, first, you have to understand that Florida law doesn't recognize a joint venture as a specific legal entity. When you and your partner start a business without filing any paperwork, you've likely created what the law calls a general partnership by default. And trust me, that's the riskiest business structure possible. Why, you may ask? Because in a general partnership, you are personally on the hook, not just for the business's debts, but for your partner's actions also. If they take out a loan and vanish, creditors can come after your house and your savings. And on top of that, oral agreements are a nightmare to prove in court. What happens when your memory of the deal is different from your partner's? Whose version does the judge believe? And Florida's statute of frauds complicates this even more, requiring certain contracts to be in writing to be enforceable. This is especially true for agreements that can't be performed within 1 year of deals that involve real estate. Now, relying on a verbal promise is like building a house on quicksand. When the ground starts to shake, and believe me, in business, it always does, everything is going to collapse. Now let's move beyond legal theory and get real. I want to share 3 nightmare scenarios that I see play out again and again. Nightmare number 1, the money versus sweat equity disaster. Now picture this. Maria is a designer with a brilliant idea. David has the capital to fund it. They meet for coffee, the energy is electric, and they shake on it. David agrees to put in $100,000 and Maria agrees to contribute her sweat equity, her time, her designs, her contacts. They decide to split the profits 50-50. Now, the first 6 months are great. Then sales are down. David, watching his investment shrink, starts getting anxious. He sees Maria take a long lunch and thinks, I put my life savings into this, and she's not hustling? Meanwhile, Maria is pulling 70-hour weeks, wrestling with manufacturers, and pouring every ounce of her creativity into this thing. She feels more like David, just throws money at problems and doesn't get the grind. She's thinking, he's just an investor. I'm the one actually building this company. The resentment builds. Arguments start because nothing was written down. No clear roles, no metrics for Maria's work, no process for making decisions. That 50-50 split suddenly feels totally unfair to both of them. Their dream venture devolves into a bitter, money-dragging legal war. Now, this is a classic and completely avoidable sweat equity nightmare. Nightmare number 2, if you didn't think number 1 was bad enough, is the exit impasse. Here's another disaster I see all the time. 2 friends, Alex and Ben, let's call them, start a booming tech firm in Miami. For 5 years, they're unstoppable, but then life happens. Alec gets married and wants to move out of the state. He tells Ben, hey, I need to leave the business, so you need to buy me out. Ben is floored. The business doesn't have that kind of cash just sitting around. He says, I could just buy you out. Why don't you find someone to buy your half? Alex then finds a buyer, but Ben can't stand the guy. No way, Ben says, I'm not working with him. I'll find someone. Now, the person Ben finds offers 40% less than Alex's buyer. Now they're stuck. Alex feels like he's been held hostage, unable to move on with his life or get the money he earned. Ben feels like Alex is abandoning their baby and trying to force a stranger onto him. Their friendship is toast. Now the business suffers as they spend more time fighting than working. No, I've seen partners get locked out of bank accounts in situations like this. And why? They never created an exit plan. There was no buyout mechanism, no valuation formula, nothing. Their failure to plan for the end trapped them both in a partnership neither want it anymore. Gets worse. Here's nightmare number 3, the surprise liability catastrophe. This last one is what can truly wreck you financially. Let's talk about Carlos, who starts a small construction business in Jacksonville with a partner. They do all on a handshake, creating a general partnership. Now, Carlos is the face of the business, managing projects, while his partner handles the books. One day, Carlos gets a call from a lawyer. He's being sued for $150,000. It turns out his partner, who developed the gambling problem, had been ordering materials on credit and using business funds to cover his debts. Carlos is completely blindsided. Remember what I said about general partnerships? Each partner is personally liable for all business debts, even those racked up by the other partner without their knowledge. Now, the supplier's lawsuit isn't just against the business, it's against Carlos personally because they didn't form an LLC for liability protection or have a written agreement with financial controls. Carlos is now on the hook for the full $150,000. His partner's secret mistakes have put his family home and savings on the line. This isn't just a business problem, it's a personal financial catastrophe born from a simple, trusting handshake. Now, understanding these partnership disasters and how to prevent them could be the difference between building a successful venture and losing everything. Now, if you're finding this valuable, take a second to hit that like button and subscribe to this channel. I share critical legal strategies for business owners every week, and you don't want to miss what could protect your livelihood. So let's keep going. Now, hearing these stories, you might think going into business with someone is a terrible idea. Well, I'm here to tell you it's not. The problem isn't the partnership, it's the lack of a blueprint. The solution is a comprehensive written joint venture agreement or even an operating agreement for an LLC. This document is your shield. It's the rule book you write in the good times to protect you during the bad times. Now, a strong agreement doesn't have to be 100 pages, but it must include what I call the 4 keys to a successful partnership. So let me give them to you. Key number 1, contributions and compensation. Your agreement needs to state exactly who is putting in what: cash, property, skills, or time. You need to be specific here. If it's sweat equity, well, define what is sweat equity. What does that mean? How many hours? What specific jobs? Then you detail how profits, and just as importantly, losses, will be split. Now, this pillar prevents the money versus sweat equity nightmare. I see this all the time. Now, the next key is key number 2, the roles, responsibilities, and decision-making. This is all about governance. Who's the boss? Who handles the money? Who's in charge of sales? Just as critical, what decisions can one partner make alone and what requires a unanimous vote? Big decisions like taking on debt or selling the company should always require everyone to agree. Now, this key stops one partner from going rogue and creating a surprise catastrophe. Key number 3 is the exit strategy. Think of this as your business prenup. Your agreement must have a clear exit plan. It should cover events like a partner's death, disability, or just wanting to leave. It needs to lay out a process for valuing the business and include buyout rules, like giving the remaining partners the right of first refusal to buy the departing partner's share. This pillar is your escape hatch from the exit impasse nightmare. And finally, on to key number 4, and this is so important: dispute resolution. Partners will disagree. It's gonna happen. But instead of letting small arguments blow up into massive lawsuits, your agreement should require a structured process. For example, you can require mediation with a neutral third party before anyone files a lawsuit. This one clause can save you tens of thousands of dollars in legal fees, and it might even save your business relationship. So what's the bottom line? The 3 great nightmares, fighting over contributions, getting trapped with no way out, and getting stuck with your partner's debts, are all born from the same original sin, that handshake deal I talked about earlier. In Florida, relying on a verbal agreement isn't just bad for business, it's an open invitation for disaster. Trust me, I've seen it 1,000 times. A clear written agreement isn't a sign of distrust, it's the ultimate sign of respect for your partner and for yourself and for the business you're building together. It's the solid foundation that lets your venture grow in your shared vision, not a shared nightmare. Now, I know this can feel overwhelming, especially when you're just getting excited to get your business off the ground. But if you're in Florida and thinking about a joint venture, Don't roll the dice on your future. Talk to a qualified attorney to help you draft an agreement that protects everyone involved. Now, if this video helped you understand how to protect yourself in a business partnership, make sure you like this video and subscribe to the channel for more critical insights that safeguard your business. Have you ever been in a business partnership that went south? Drop your story in the comments below. Sharing these experiences really does help others avoid these same traps. I'll see you in the next video.